Merger, ACT versus of 1898. Part 1, Preliminary, Chapter -1, 1. Short title and commencement. Extent. 2. Repealed. 3. References to Code of Criminal Procedure and other repeated enactments. Expressions in former acts. 4. Definitions. Words referring to acts. Words to have same meaning as in Pakistan Penal Code. 5. Trial of offenses under Penal Code. Trial of offenses against other laws. Part 2. Constitution and powers of criminal courts and offices. Chapter 2 of the Constitution of Criminal Courts and Offices. A. Classes of Criminal Courts. 6. Classes of Criminal Courts and Magistrates. B. Territorial Divisions. 7. Sessions, Divisions and Districts. Power to alter divisions and districts. Existing divisions and districts maintained till altered. 8. Power to divide districts into subdivisions. Existing subdivisions districts maintained. C. Courts and offices. 9. Court of Session. 10. District magistrates. 11. Officers temporarily succeeding to vacancies in office of district magistrate. 12. Subordinate magistrates. Local limits of their jurisdiction. 13. Power to put executive magistrate in charge of subdivisions. Delegation of powers to district magistrate. 14. Special judicial and executive magistrates. 15. Benches of magistrates. Powers exercisable by bench in absence of special direction. 16. Power to frame rules for guidance of benches. 17. Subordination of judicial magistrates and benches to sessions judge. Subordination of executive magistrates to district magistrate. Subordination of executive magistrates to subdivisional magistrate. Subordination of assistant sessions judges to sessions judge. D. Courts of Presidency magistrates. 18 to 21 omitted. E. Justices of the Peace. 22. Justice of the Peace for the Mufassal. Punjab Amendment. 22. Appointment of Justices of the Peace. 22a. Powers of Justices of the Peace. 22b. Duties of Justices of the Peace. 23 to 24. Repealed. 25. Ex officio Justices of the Peace. F. Suspension and removal. 26 to 27 repeated. Chapter 3. Powers of Courts. A. Description of offenses cognizable by each court. 28. Offenses under Penal Code. 29. Offenses under other laws. 29a. Omitted. 29b. Jurisdiction in the cases of juveniles. 30. Offenses not punishable with death. B. Sentences which may be passed by courts of various classes. 31. Sentences which High Court and Sessions judges may pass. 32. Sentences which magistrates may pass. 33. Power of magistrates to sentence to imprisonment in default of fine. 34. higher powers of certain district magistrates. 34a. Omitted. 35. Sentence in case of conviction of several offenses at one trial. Maximum term of punishment. C. Ordinary and additional powers. 36. Ordinary powers of magistrates. 37. Additional powers conferable on magistrates. 38. Control of district magistrates' investing power. D. Conferment, continuance and cancellation of powers. 39. Mode of conferring powers. 40. Powers of officers appointed. 41. Powers may be cancelled. Part 3. General Provisions. Chapter IV. Evading information to the magistrates, the police and persons. Making arrests. 42. Public when to assist magistrate and police. 43. Aid to person, other than police officer, executing warrant. 44. Public to give information of certain offenses. 45. Village headmen, accountants, landholders and others bound to report certain matters. Appointment of village headmen by district magistrate or subdivisional magistrate in certain cases for purposes of this section. Chapter V. Of arrest, escape and retaking. A. Arrest generally. 46. Arrest how made. Resisting endeavor to arrest. 47. Search of place entered by person sought to be arrested. 48. Procedure where ingress not obtainable. Breaking open zanana. 49. Power to break open doors and windows for purposes of liberation. 50. No unnecessary restraint. 51. Search of arrested persons. 52. Mode of searching women. 53. Power to seize offensive weapons. B. Arrest without warrant. 54. When police may arrest without warrant. 55. Arrest of vagabonds, habitual robbers, etc. 56. Procedure when police officer deputes subordinate to arrest without warrant. 57. Refusal to give name and residence. 58. Pursuit of offenders into other jurisdiction. 59. Arrest by private persons and procedure on such arrest. 60. Person arrested to be taken before magistrate or officer in charge of police station. 61. Persons arrested not to be detained more than 24 hours. 62. Police to report apprehensions. 63. Discharge of person apprehended. 64. Offense committed in magistrate's presence. 65. Arrest by or in presence of magistrate. 66. Power, on escape, to pursue and retake. 67. Provisions of sections 47, 48 and 49 to apply to arrest. Under section 66. 47. Search of place entered by person sought to be arrested. 48. Procedure where ingress not obtainable. Breaking open Zanana. 49. Power to break open doors and windows for purposes of liberation. 50. No unnecessary restraint. 51. Search of arrested persons. 52. Mode of searching women. 53. Power to seize offensive weapons. B. Arrest without warrant. 54. When police may arrest without warrant. 55. Arrest of vagabonds, habitual robbers, etc. 56. Procedure when police officer deputes subordinate to arrest without warrant. 57. Refusal to give name and residence. 58. Pursuit of offenders into other jurisdiction. 59. Arrest by private persons and procedure on such arrest. 60. Person arrested to be taken before magistrate or officer in charge of police station. 61. Persons arrested not to be detained more than 24 hours. 62. Police to report apprehensions. 63. Discharge of person apprehended. 64. Offense committed in magistrate's presence. 65. Arrest by or in presence of magistrate. 66. Power, on escape, to pursue and retake. 67. Provisions of sections 47, 48 and 49 to apply to arrest. Under section 66. Chapter V, of processes to compel appearance. A. Summons. 68. Form of summons. Summons by whom served. 69. Summons how served. Signature of receipt for summons. 70. Service when person summoned cannot be found. 71. Procedure when service cannot be effected as before provided. 72. Service on servant of state or of railway company. 73. Service of summons outside local limits. 74. Proof of service in such cases and when serving officer not present. B. Warrant of arrest. 75. Form of warrant of arrest. Continuance of warrant of arrest. 76. Court may direct security to be taken. Recognizance to be forwarded. 77. Warrants to whom directed. Warrants to several persons. 78. Warrant may be directed to landholders, etc. 79. Warrant directed to police officer. 80. Notification of substance of warrant. 81. Person arrested to be brought before court without delay. 82. Where warrant may be executed. 83. Warrant forwarded for execution outside jurisdiction. 84. Warrant directed to police officer for execution outside jurisdiction. 85. Procedure on arrest of person against whom warrant issued. 86. Procedure by magistrate before whom person arrested is brought. 86A. Procedure for removal in custody to tribal areas. C. Proclamation and attachment. 87. Proclamation for person absconding. 88. Attachment of property of person absconding. 89. Restoration of attached property. D. Other rules regarding processes. 90. Issue of warrant in lieu of or in addition to summons. 91. Power to take bond for appearance. 92. Arrest by breach of bond for appearance. 93. Provisions of this chapter general applicable to summons and warrants of arrest. E. Special rules regarding processes issued for service or execution. Outside Pakistan and processes received from outside Pakistan for service or execution within Pakistan. 93A. Sending of summons for service outside Pakistan. 93B. Sending of warrants for execution outside Pakistan. 93C. Service and execution in Pakistan of processes received from outside Pakistan. Chapter 7. Of processes to compel the production of documents and other movable property and for the discovery of persons wrongfully confined. A. Summons to produce. 94. Summons to produce document or other thing. 95. Procedure as to letters and telegrams. B. Search warrants. 96. When search warrant may be issued. 97. Power to restrict warrant. 98. Search of house suspected to contain stolen property, forged documents, etc. 99. Disposal of things found in search beyond jurisdiction. 99A. Power to declare certain publications and forfeited and to issue search warrants for the same. 99B. Application to High Court to set aside order of forfeiture. 99C. Omitted. 99D. Order of High Court setting aside forfeiture. 99E. Evidence to prove nature or tendency of newspaper. 99F. Procedure in High Court. 99G. Jurisdiction barred. C. Discovery of persons wrongfully confined. 100. Search for persons wrongfully confined. D. General provisions relating to searches. 101. Direction, etc. of search warrants. 102. Persons in charge of closed place to allow search. 103. Search to be made in presence of witnesses. Occupant of place searched may attend. E. Miscellaneous. 104. Power to impound document, etc., produced. 105. Magistrate may direct search in his presence. Part 4. Prevention of offenses. Chapter Veal of security for keeping the peace and for good behavior. A. Security for keeping the peace on conviction. 106. Security for keeping the peace on conviction. B. Security for keeping the peace in other cases and security for good behavior. 107. Security for keeping the peace in other cases. Procedure if magistrate not empowered to act under subsection 1. 108. Security for good behavior from persons disseminating seditious matter. 109. Security for good behavior from vagrants and suspected persons. 110. Security for good behavior from habitual offenders. 111. Proviso as to European vagrants. Repeated. 112. Order to be made. 113. Procedure in respect of person present in court. 114. Summons or warrant in case of person not so present. 115. Copy of order under Section 112 to accompany summons or warrant. 116. Power to dispense with personal attendance. 117. Inquiry as to truth of information. 118. Order to give security. 119. Discharge of person informed against. C. Proceedings in all cases subsequent to order to furnish security. 120. Commencement of period for which security is required. 121. Contents of bond. 122. Power to reject sureties. 123. Imprisonment in default of security. Proceedings when to be laid before High Court or Court of Session. Kind of imprisonment. 124. Power to release persons imprisoned for failing to give security. 125. Power to district magistrate to conceal any bond for keeping the peace or good behavior. 126. Discharge of sureties. 126a. Security for unexpired period of bond. Chapter X. Unlawful assemblies and maintenance of public peace and security. 127. Assembly to disperse or command of magistrate or police officer. 128. Use of civil force to disperse. 129. Use of military force. 130. Duty of officer commanding troops required by magistrate to disperse assembly. 131. Power of commissioned military officer to disperse assembly. 131a. Power to use military force for public security and maintenance of law and order. 132. Protection against prosecution for acts done under this chapter. 132a. Definitions. Chapter X. PUBUC nuisances. 133. Conditional order for removal of nuisance. 134. Service or notification of order. 135. Person to whom order is addressed to obey or show cause or claim jury. 136. Consequence of his failing to do so. 137. Procedure where he appears to show cause. 138. Procedure when he claims jury. 139. Procedure where jury finds magistrate's order to be reasonable. 139a. Procedure where existence of public right is denied. 140. Procedure on order being made absolute. Consequences of disobedience to order. 141. Procedure on failure to appoint jury or omission to return verdict. 142. Injunction pending inquiry. 143. Magistrate may prohibit repetition or continuance of public nuisance. Chapter 11. Temporary orders in urgent cases of nuisance or apprehended danger. 144. Power to issue order absolute at once try urgent cases of nuisance or apprehended danger. Chapter 12. Disputes as to immovable property. 145. Procedure where dispute concerning land, etc. is likely to cause breach of peace. Inquiry as to possession. Party in possession to retain possession until legally evicted. 146. Power to attach subject of dispute. 147. Dispute concerning rights of use of immovable property, etc. 148. Local inquiry. Order as to costs. Chapter 13. Preventive action of the police. 149. Police to prevent cognizable offenses. 150. Information of design to commit such offenses. 151. Arrest to prevent such offenses. 152. Prevention of injury to public property. 153. Inspection of weights and measures. Part 5. Information to police and their powers to investigate. Chapter 14. 154. Information in cognizable cases. 155. Information in non-cognizable cases. Investigation into non-cognizable eases. 156. Investigation into cognizable cases. 157. Procedure where cognizable offense suspected. Where local investigation dispensed with. Where police officer in charge sees no sufficient ground for investigation. 158. Reports under Section 157 how submitted. 159. Power to hold investigation or preliminary inquiry. 160. Police officers' power to require attendance of witnesses. 161. Examination of witnesses by potted. 162. Statements to police ought to be signed. Use of such statements in evidence. 163. No inducement to be offered. 164. Power to record statements and confessions. 165. Search by police officer. 166. When officer in charge of police station may require another to issue search warrant. 167. Procedure when investigation cannot be completed in 24 hours. 168. Report of investigation by subordinate police officer. 169. Release of accused when evidence deficient. 170. Case to be sent to magistrate when evidence is sufficient. 171. Complainants and witnesses not to be required to accompany police officer. Complainants and witnesses not to be subjected to restraint. Recusant complainant. Witness may be forwarded in custody. 172. Diary of proceedings in investigation. 173. Report of police officer. 174. Police to inquire to report in suicide, etc. 175. Power to summon persons. 176. Inquiry by magistrate into cause of death. Power to disinter corpses. Part 6. Proceedings in prosecutions. Chapter 15 of the jurisdiction of the criminal courts of inquiries and trials. A place of inquiry or trial. 177. Ordinary place of inquiry and trial. 178. Power to order cases to be tried in different sessions divisions. 179. Accused triable in district where act is done or where consequence ensues. 180. Place of trial where act is offense by reason of relation to other offense. 181. Being a thug or belonging to a gang of dacoits, escape from custody, etc. Criminal misappropriation and criminal breach of trust. Theft, kidnapping and abduction. 182. Place of inquiry or trial where scene of offense is uncertain or not in one district only, or where offense is continuing or consists of several acts. 183. Offense committed on a journey. 184. Offense against Railway, Telegraph, Post Office and Arms Act. 185. High Court to decide in case of doubt, district where inquiry or trial shall take place. 186. Power to issue summons or warrant for offense committed beyond local jurisdiction. Magistrate's procedure on arrest. 187. Procedure where warrant issued by subordinate magistrate. 188. Liability of offenses committed outside Pakistan. Political agents to certify fitness of inquiry into charges. 189. Power to direct copies of depositions and exhibits to be received in evidence. B. Conditions requisite for initiation of proceedings. 190. Cognizance of offense by magistrates. 191. Transfer on application of accused. 192. Transfer of cases by magistrate. 193. Cognizance of offenses by courts of session. 194. Cognizance of offenses by High Court. 195. No court shall take cognizance. Prosecution for contempt of lawful authority of public servants. Prosecution for certain offenses against public justice. Prosecution for certain offenses relating to documents given in evidence. 196. Prosecution for offenses against the state. 196A. Prosecution for certain classes of criminal conspiracy. 196. B. Preliminary inquiry in certain cases. 197. Prosecution of judges and public servants. Power of President or Governor as to prosecution. 198. Prosecution for breach of contract, defamation and offenses against marriage. 198A. Prosecution for defamation against public servants in respect of their conduct in the discharge of public functions. 199. Prosecution for adultery or enticing a married woman. 199A. Objection by lawful guardian to complaint by person other than person aggrieved. 199B. Form of authorization under second proviso to section 198 or 199. Chapter 16, of Complaints to Magistrates. 200. Examination of complainant. 201. Procedure by magistrate not competent to take cognizance of the case. 202. Postponement of issue of process. 203. Dismissal of complaints. Chapter 17, of the commencement of proceedings before court. 204. Issue of process. 194. Cognizance of offenses by High Court. 195. No court shall take cognizance. Prosecution for contempt of lawful authority of public servants. Prosecution for certain offenses against public justice. Prosecution for certain offenses relating to documents given in evidence. 196. Prosecution for offenses against the state. 196a. Prosecution for certain classes of criminal conspiracy. 196. b. Preliminary inquiry in certain cases. 197. Prosecution of judges and public servants. Power of President or Governor as to prosecution. 198. Prosecution for breach of contract, defamation and offenses against marriage. 198a. Prosecution for defamation against public servants in respect of their conduct in the discharge of public functions. 199. Prosecution for adultery or enticing a married woman. 199a. Objection by lawful guardian to complaint by person other than person aggrieved. 199b. Form of authorization under second proviso to section 198 or 199. Chapter 16, of Complaints to Magistrates. 200. Examination of complainant. 201. Procedure by magistrate not competent to take cognizance of the case. 202. Postponement of issue of process. 203. Dismissal of complaints. Chapter 17, of the commencement of proceedings before court. 204. Issue of process. 205. Magistrate may dispense with personal attendance of accused. Chapter 18, of inquiry into cases triable by the Court of Session or High Court. 206 to 220. Omitted. Chapter 19, of the charge, form of charges. 221. Charge to state offense. Specific name of offense sufficient description. How stated where offense has no specific name. What implied in charge. Language of charge. Previous conviction when to be set out. 222. Particulars as to time, place and person. 223. When manner of committing offense must be stated. 224. Words in charge taken in sense of law under which offense is punishable. 225. Effect of errors. 226. Omitted. 227. Court may alter charge. 228. When trial may proceed immediately after alteration. 229. When new trial may be directed or trial suspended. 230. Stay of proceedings if prosecution of offense unaltered. Charge require previous sanction. 231. Recall of witnesses when charge altered. 232. Effect of material error. 205. Magistrate may dispense with personal attendance of accused. Chapter 18 of Inquiry into Cases Triable by the Court of Session or High Court. 206 to 220. Omitted. Chapter 19 of the Charge. Form of Charges. 221. Charge to state offense. Specific name of offense. Sufficient description. How stated where offense has no specific name. What implied in charge. Language of charge. Previous conviction when to be set out. 222. Particulars as to time, place and person. 223. When manner of committing offense must be stated. 224. Words in charge taken in sense of law under which offense is punishable. 225. Effect of errors. 226. Omitted. 227. Court may alter charge. 228. When trial may proceed immediately after alteration. 229. When new trial may be directed or trial suspended. 230. Stay of proceedings if prosecution of offense unaltered. Charge require previous sanction. 231. Recall of witnesses when charge altered. 232. Effect of material error. Joinder of charges. 233. Separate charges for distinct offenses. 234. Three offenses of same kind within year may be charged together. 235. Trial for more than one offense. Offense falling within two definitions. Acts constituting one offense, but constituting when combined a different offense. 236. When it is doubtful what offense has been committed. 237. When a person is charged with one offense, he can be convicted of another. 238. When offense proved included in offense charged. 239. What persons may be charged jointly. 240. Withdrawal of remaining charges on conviction on one of several charges. Chapter XX of the trial of cases by magistrates. 241. Procedure in trial of cases. 241A. Supply of statements and documents to the accused. 242. Charge to be framed. 243. Conviction on admission of truth of accusation. 244. Procedure when no such admission is made. 244A. Statement made under Section 164. 245. Acquittal. Sentence. 245A. Procedure in cases of previous convictions. 246. Omitted. 247. Non-appearance of complainant. 248. Withdrawal of complaint. 249. Power to stop proceeding when no complaint. 249A. Power of magistrate to acquit accused at any stage. Frivolous accusations in cases tried by magistrate. 250. False, frivolous or vexatious accusations. 250a. Special summons in case of petty offenses. Chapter 21. Of the trial of warrant cases by magistrates. 251 to 259. Omitted. Chapter 22. Of summary trials. 260. Power to try summarily. 261. Power to invest bench of magistrates invested with less powers. 262. Procedure prescribed in Chapter 20 applicable. Limit of imprisonment. 263. Record in cases where there is no appeal. 264. Record in appealable cases. 265. Language of record and judgment. Bench may be authorized to employ clerk. Chapter 22a. Trials before high courts and courts of session. 265a. Trials before court of session to be conducted by public prosecutors. 265b. Procedure in cases triable by high courts and courts of session. 265c. Supply of statements and documents to the accused. 265d. When charge is to be framed. 265e. Plea. 265f. Evidence for prosecution. 265g. Summoning up by prosecutor and defense. 265h. Acquittal or conviction. 265 to 1. Procedure in case of previous conviction. 265j. Statement under Section 164 admissible. 265k. Power of court to acquit accused at any stage. 265l. Power of Advocate General to stay prosecution. 265m. Time of holding sittings. 265n. Place of holding sittings. Chapter 23. Of the trials before High Court and Courts of Session. 266-336. Omitted. Chapter 24. General provisions as to inquiries and trials. 337. Tender of pardon to accomplice. 338. Power to grant tender of pardon. 339. Commitment of person to whom pardon has been tendered. 339a. Procedure in trial of person under Section 339. 340. Right of person against whom proceedings are instituted to be defended and his competency to be a witness. 341. Procedure where accused does not understand proceedings. 342. Power to examine the accused. 343. No influence to be used to induce disclosures. 344. Power to postpone or adjourn proceedings. Remand. Reasonable cause for remand. 345. Compounding offense. 346. Procedure of magistrate in cases which he cannot dispose of. 347. Procedure when after commencement of trial, magistrate finds case should be tried by court of session or high court. 348. Trial of persons previously convicted of offenses against coinage, stamp law or property. 349. Procedure when magistrate cannot pass sentence sufficiently severe. 350. Conviction or evidence partly recorded by one presiding officer and partly by another. 350A. Changes in constitution of benches. 351. Detention of offenders attending court. 352. Courts to be open. Chapter 25. Of the mode of taking and recording evidence in inquiries and trials. 353. Evidence to be taken in presence of accused. 354. Manner of recording evidence. 355. Record in trial of certain cases by first and second class magistrates. 356. Record in other cases. Evidence given in English. Memorandum when evidence not taken down by the magistrate or judge himself. 357. Language or record of evidence. 358. Option to magistrate in cases under Section 355. 359. Mode of recording evidence under Section 356 or Section 357. 360. Procedure in regard to such evidence when completed. 361. Interpretation of evidence to accused or his pleader. 362. Omitted. 363. Remarks respecting demeanor of witness. 364. Examination how recorded. 365. Record of evidence in High Court. Chapter 26. Of the judgment. 366. Mode of delivering judgment. 367. Language of judgment. Contents of judgment. Judgment in alternative. 366. Sentence of death. 369. Court not to alter judgment. 370. Omitted. 371. Copy of judgment, etc. To be given to accused. Case of person sentenced to death. 372. Judgment when to be translated. 373. Court of Session to send copy of finding and sentence to District Magistrate. Chapter 27. Of the submission of sentences for confirmation. 374. Sentence of death to be submitted by Court of Session. 375. Power to direct further inquiry to be made or additional evidence to be taken. 376. Power to High Court to confirm sentence or annual conviction. 377. Confirmation of new sentence to be signed by two judges. 378. Procedure in case of difference of opinion. 379. Procedure in cases submitted to High Court for confirmation. 380. Procedure in cases submitted by magistrate not empowered to act under Section 562. Chapter 28. Of execution. 381. Execution of order passed under Section 376. 382. Postponement of capital sentence on pregnant woman. 382A. Postponement of execution of sentences of imprisonment under Section 476 or 4. A period of less than 1 year. 382B. Period of detention to be considered while awarding sentence of imprisonment. 382C. Scandalous or false and frivolous pleas to be considered in passing sentence. 383. Execution of sentences of transportation or imprisonment in other cases. 384. Direction of warrant for execution. 385. Warrant with whom to be lodged. 386. Warrant for levy of fine. 387. Effect of such warrant. 388. Suspension of execution of sentence of imprisonment. 389. Who may issue warrant. 390. Execution of sentence of whipping only. 391. Execution of sentence of whipping, in addition to imprisonment. 392. Mode of inflicting punishment. Limit of number of stripes. 393. Not to be executed by installments, exemptions. 394. Whipping not to be inflicted if offender not in fit state of health. Stay of execution. 395. Procedure if punishment cannot be inflicted under Section 394. 396. Execution of sentence on escaped convicts. 397. Sentence of offender already sentenced for another offense. 398. Saving as to Sections 396 and 397. 399. Confinement of youthful offenders in reformatories. 400. Return of warrant on execution of sentence. Chapter 29. Of suspensions, remissions and commutations of sentences. 401. Power to suspend or remit sentences. 402. Power to commute punishment. 402A. Sentence of death. 402B. Certain restrictions on the exercise of powers by provincial government. 402C. Remission or commutation of certain sentences not to be without consent. Chapter XXX. Of previous acquittals or convictions. 403. Person once convicted or acquitted not to be tried for same offense. Part 7. Of Appeal, Reference and Revision. Chapter 31. Of Appeals. 404. Unless otherwise provided, no appeal to tie. 405. Appeal from order rejecting application for restoration of attached property. 406. Appeal from order requiring security for keeping the peace or for good behavior. 400A. Appeal from order refusing to accept or rejecting a surety. 407. Omitted. 408. Appeal from sentence of assistant sessions judge or judicial magistrate. 409. Appeals to Court of Session how heard. 410. Appeal from sentence of Court of Session. 411. Omitted. 411A. Appeal from sentence of High Court. 412. No appeal in certain cases when accused pleads guilty. 413. No appeal in petty cases. 414. No appeal from certain summary convictions. 415. Proviso to sections 413 and 414. 415A. Special right of appeal in certain cases. 416. Repealed. 417. Appeal in case of acquittal. 418. Appeal on what matters admissible. 419. Petition of appeal. 420. Procedure when appellant in jail. 421. Summary dismissal of appeal. 422. Notice of appeal. 423. Powers of appellate court in disposing of appeal. 424. Judgments of subordinate appellate courts. 425. Order by High Court on appeal to be certified to lower court. 426. Suspension of sentence pending appeals. Release of appellant on bail. 427. Arrest of accused in appeal from acquittal. 428. Appellate court may take further evidence or direct it to be taken. 429. Procedure where judges of Court of Appeal are equally divided. 430. Finality of orders on appeal. 431. Abatement of appeals. Chapter 32. Of reference and revision. 432-434. Omitted. 435. Power to call for records of inferior courts. 436. Power to order further inquiry. 437. Omitted. 438. Omitted. 439. High Court's powers of revision. 440. Option with court to hear parties. 441. Omitted. 442. High Court's order to be certified to lower court or magistrate. Part 8. Special Proceedings. Chapter 33. 443 to 463. Omitted. Chapter 34.